on her right to her face. I said, I am not going to do this anymore. I will not tolerate it anymore. Today is when it stops.
So probably not shocking to people that video is essentially proving premeditation, right? Premeditation can actually be developed in the moment, but if you have several moments, it doesn't have to be I thought about it and planned it out for weeks and months, which, I mean, she might have, I don't know. But it doesn't have to be weeks and months. It can be just 10 seconds of premeditation. The fact that she grabbed a gun, walked across the street, and is on film walking up to Shauna's house, yeah, that definitely is premeditated murder. She was on their property, which was also trespass. I didn't look up Kentucky's criminal trespass statute. A lot of states, if you're trespassing with the intent to commit a felony, it's felony trespass. So it could be that. Anybody that's ever had a crappy neighbor knows that it is one of the worst things that can happen to you. There's a whole Netflix documentary series about it, and we're going to check it out today.
Muslims, they follow the same satanic book that they all do. They all read the same pages. Here's the thing. I don't even see Islam as a religion. It's a death cult. A glorified death cult. That's all it is. That's all it ever will be. I don't like you.
You don't like me? Why?
No, because you're Muslim.
Who said I'm Muslim?
If you're not Muslim, you're a Muslim lover.
Something I didn't tell you is I'm Jewish.
I don't think you're into Jesus. You're Jewish, you're Muslim, are you atheist? Are you fag too?
Fag?
Yeah.
I thought it was a little bit crazy. But she thought it was cool that she was in this video protesting. And then I started thinking she may be a little racist. This is not going to work.
She may be a little
David
racist?
Did not like
okay.
her at all. He said she's trouble from the beginning. She's loud-mouthed, and she is an attention seeker. He was a very good judge of people.
First legal issue that comes to mind right after this is a lot of people say, yeah, the First Amendment has its limitations. That's true. There are some that have been laid out by the Supreme Court. Hate speech is not one of them. In fact, hate speech does not have, at this point, a federal definition or one in Arizona. So while a lot of people would define what she was just saying as hate speech, it still is, at this point, protected by the First Amendment. So she can say what she just said, no matter how stupid it is not illegal. So at this point, I don't know if people are going, oh, they should have called the cops right there. No, that was protected First Amendment behavior.
While Mom was at the tanning salon and helping her friends, Frances came out to the salon and kind of was making a scene, and then my mom told her she had to leave.
And then Frances made a post on Facebook to the business saying that she's going to report them for me working there. She was accusing me of working while I was on disability, and she was going to try to report me. But I was not working. I was just volunteering and hanging out.
So at this point, making a threat to say we're going to report somebody is not the same as reporting somebody. You might be brushing into some harassing behavior, which we'll touch on here in a minute, because I can see that this is definitely escalating. But at this point, this is sort of the first action. And at this point, it probably wouldn't even qualify for an injunction against harassment here in Arizona. And in Kentucky, I'll show you, they're even a lot harder to get there. So let's keep going.
And I told her, mind your own business. Nobody's bothering you, and we don't want to be bothered. I did ask her why she was doing it, and she just laughed. And she said, because I can. And then we got into a fight. It wasn't just pulling hair, slapping. It was a fight. David come and broke it up and drug me off of her. Frances called 911.
Okay, now what's interesting there is that animation that we saw, I don't know if that was inspired by something that she said off camera, but the animation that we saw is that the person here in the film is depicted as being the aggressor there. I don't know if that's actually how it happened or if that's just how Netflix decided to animate it or what, but that to me is important because she went over to her neighbor's house. She was the one that, knocked on the door, started the situation, and then if she was the aggressor in addition to that, then you could definitely have assault charges there. So, okay, let's see where it's going. We got a 911 call here.
Frances told the police that I took a hoe and that I hit her with it and that David beat her with it. And she demanded that I be arrested immediately.
She didn't have any injuries on her that I seen to show that she was struck with the stick. I can't make an arrest on an assault unless there's very serious physical injuries that we can see.
I mean, was we scuffed up from rolling on the ground? Absolutely. But no, she was fine. Then all of a sudden the next day she had a neck brace on, an arm brace on.
Okay, so let's stop there and go over some of the interesting points. Okay, we had a sheriff deputy say, I can't make an arrest unless I can see some serious physical injuries. Okay, well, in Kentucky, let's have a look at their assault statute. So the assault in the first degree, or what we would probably call aggravated assault with a deadly weapon here in Arizona, in Kentucky, says a person is guilty of assault in the first degree when he intentionally causes serious physical injury to another person by means of a deadly weapon or a dangerous instrument, or under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a grave risk of death. Okay, that one's not really applying. It's the first section 1A here. Intentionally causes serious physical injury. Now that sounds like what this deputy is talking about. And yeah, if he's saying, in order for a person to be charged with assault in the first degree, I've got to see some serious physical injuries, I would totally agree with him. But in Kentucky, I already just had a peek at their statute. They also have assault in the second degree, third degree, and fourth degree. So let's look at those. Okay, assault in the second degree in Kentucky essentially has similar language to assault in the first degree, so I'm assuming that they just charge this when the physical injuries are not as serious as assault in the first degree. Okay, let's see third degree. So for Kentucky, assault in the third degree, a person is guilty of assault in the third degree when the actor recklessly with a deadly weapon or dangerous instrument or intentionally causes or attempts to cause physical injury to a state, county, city, or federal peace officer. That's not what we're facing here. Okay, employee of a detention facility, nope. A healthcare provider, nope. An employee of the Department for Community-Based Services, Paid volunteer emergency medical, no. Paid volunteer member of, no. Okay, so it's looking like most of these are essentially what we would call in Arizona aggravated assault based on who you assaulted rather than how you assaulted an individual. In this case, it's just two neighbors fighting. Doesn't look like any of these are going to apply. Okay, now if the husband was claiming that he was assaulted, I believe his name is David. If David claimed that he was assaulted under here, section 1A2, an employee of a detention facility. He was an employee of a detention facility, and they even said he was coming home from work, and in the animation showed him with his badge on. Typically speaking, statutes say while in the course of their employment or in the course of their duties, but I'm not actually seeing that in this statute, so that's a fascinating one. If he had claimed assault, the neighbor probably could have been charged with assault in the third degree under this statute. But as for the two ladies, we're still looking for how could they have charged assault in this case. Let's look at assault in the fourth degree. Pause real quick because a lot of states actually have assault and battery, and a lot of people watching are probably saying, wait a minute, she should have been charged with battery. We're not talking about assault. A lot of states still have the common law definitions. Assault is the threat to touch. Battery is the touching. Many states now have combined them into one assault charge. And that's what we have in Arizona. And it looks like Kentucky has done a very similar thing. Although they're kind of titled differently than ours, we have what looks like very similar statutes. Okay, assault in the fourth degree. A person is guilty of assault in the fourth degree when he intentionally or wantonly causes physical injury to another person, or with recklessness, he causes physical injury to another person by means of a deadly weapon or a dangerous instrument. Assault in the fourth degree is a Class A misdemeanor. Okay, so here in Arizona we call this misdemeanor assault or basic assault, or simple assault. And then we have on top of that aggravated assault. So it looks like Kentucky starts with assault in the 4th degree is your simple assault, and then it is aggravated by different things. It goes up to assault in the 3rd, 2nd, or 1st degree. Okay, here, yes, you do have intentionally or wantonly causes physical injury to another person. So with that officer saying, if I'm going to have an assault charge, I've got to see serious physical injuries. Well, no, not for a misdemeanor assault, not for this one right here. This is just any intentional or wantonly causes physical injury to another person. So really, this one is your classic, who was the aggressor? You assaulted them, okay? So I'm not seeing how there shouldn't have been any charges. It sounds like there should have been some charges, whoever the aggressor was. But maybe the officer off camera said, I just wasn't able to determine who an aggressor was. Now, as for the hoe, back there we had assault with a deadly weapon. A hoe definitely can be considered a deadly weapon. I'm not aware of any state that doesn't consider it a deadly weapon. And remember, it's not a device that is designed to cause death. It's any device which could cause death when used in this way. And if you're swinging a hoe and you hit somebody in the head, it definitely could cause death. So if she could actually prove that, then maybe she could have had an assault with, it could have been a class 2 or maybe even a class 1, it looks like, under Kentucky law. But the officer was saying, I wasn't seeing injuries to support her claiming that she was attacked with a hoe. Now, we did see already that this lady here is saying, okay, and then Frances started showing up with a neck brace and with her arm in a sling, looking like she's actually trying to create or simulate the injuries that would justify one of these charges. Either assault in the 2nd degree or 1st degree, but let's see where the story's going.
Dave calls me, lets me know that my mom and Frances physically assaulted each other, and that Frances was pressing charges and wanted to see her in jail. I was kind of in shock. And I've never seen my mom act like that.
Okay, now we didn't hear anything yet as to whether they have any evidence for the hitting with a hoe and threatening to kill her and all of that kind of stuff. And so probably some people are wondering, could you get a false report out of that? The hard part about false reports, well, first off, let's look at the Kentucky statute. So falsely reporting an incident in Kentucky, a person is guilty of falsely reporting an incident when the person reports to law enforcement authorities an offense or incident within their official concern knowing it did not occur. Okay, or furnishes law enforcement authorities with information allegedly relating to an offense or incident within their official concern when the person knows he or she has no information related to that. No, that one probably won't work. Knowingly gives false information to any law enforcement officer with the intent to implicate another. That, according to Shauna, looks like it would apply. It looks like Frances knowingly stated that she was hit with a hoe and that Shauna threatened to kill her and that neither one of those things happened. However, remember that the burden of proof is always on the government when they're trying to prove a crime. And all that you have in this case is Shauna's word. There's only 2 people there. It's not recorded. Nobody else knows about it. It's a straightforward he said, she said situation. I don't know what Shauna admitted to police. Did she admit when she went over there, yes, I was the aggressor and I pushed her and that's how she got this misdemeanor assault charge? But did she say, no, I didn't hit her, no, I didn't, or excuse me, no, I didn't threaten her to kill her, no, I didn't hit her with a hoe? It would depend on what she admitted to, but I'm gonna guess there just wouldn't be enough evidence to do a false information charge in that case. It probably just wouldn't stick. Is it fair? Is it what we really want to hear? When somebody says they threatened to kill me, we want to say, no, you're going down for false report. No, it probably isn't fair, but it usually is the way the system works. Also, it really has to be, at least here in Arizona, to a really large degree, a false report before they're actually going to file a charge like that. When there was already an assault that occurred and they were just trying to make the assault worse, they probably wouldn't even file it.
When I got home from being released from jail, Frances was out in her yard, video recording on her phone. She was mad. She called the jail. She called the sheriff's office, demanding that they put me in jail for 18 months for assaulting her.
Okay, a misdemeanor assault here in Arizona misdemeanor maximum penalty is 6 months in jail and a $2,500 fine. Okay, so just after a quick Google search, I haven't been able to find this in statute, but it does look like it is 12 months in jail and a $500 fine. So she's demanding 18 months. That's actually beyond the maximum amount that she could even receive in that situation, and a $500 fine. So that's actually, the fine is lower than it is here in Arizona. So yeah, it sounds like Francis is demanding 50% more than what the maximum penalty would be for a first offense. Look, I don't know how things roll in Kentucky. I've never, I don't have a law license there, so I've never practiced there, but I can tell you for a first misdemeanor assault, Shauna in Arizona probably would be looking at either a diversion program or unsupervised probation and possibly a fine, but usually not both. So demanding 18 months in jail, no, unreasonable.
After my first court appearance, I wasn't no danger to no one. I was just sitting home waiting for my trial.
Shauna was under a no contact order.
Okay, so she was not released on her own recognizance. She was released on an unsecured bail or bond. It looks like she had to pay $1,000. Relatively simple or pretty close to what we would do here in Arizona, what I've seen done 1,000 times. Nothing that I'm seeing suggests good old boy system yet. All of this is just going, yep, the first offense, very small bond. Okay, yeah, I can see all that happening. It is an accused violent crime, so they'd probably do some kind of bond. Own recognizance might be for lower misdemeanors, non-violent offenses like shoplifting, things like that. But so far, this is just reading as, yep, that's how things work.
She's to have no contact with the victim, and in this case, that was Francis Sawyer. If
no contact with the victim, also how things work. Anytime there is a victim, it is part of every single release order. That's just how it goes.
I remember one weekend, David went out to start the car, and this car was across the street in my dad's property.
David Scott come here this morning, and I called the sheriff again today, called the state police also. The man that they won't protect me from pulled into the driveway beside my driveway.
Francis came up to his
father-in-law's
car.
property. Oh,
She went around the car windows, beating on the car windows, cussing and calling names.
I went over and videotaped this car sitting there.
oh, and she admitted to videotaping it.
Yeah, we put the blinder thing in front so you can't see in the car, and he'd sit there in the car, and he wouldn't roll down his window.
Good for him. Okay. All right, we need one other statute. Kentucky statutes obviously are worded a little bit differently than ours in Arizona, and I don't know, it sounds like this one is trying to accomplish the same thing as our disorderly conduct misdemeanor statute. A person is guilty of disorderly conduct in the second degree when in a public place and with intent to cause public inconvenience. That's the only part that's confusing me a little bit. Generally, our statute is targeted at an individual. It might be under another statute, but I'm not totally sure. Anyway, annoyance or alarm or wanton creating a risk thereof, he engages in fighting or violent, tumultuous, or threatening behavior, makes unreasonable noise. Now, this is exactly the same as ours, where it is directed at an individual. Going and banging on the windows, yelling at him, she's videotaping it. Essentially, you're just saying, yeah, I'm making violent or tumultuous noise. Yeah, you definitely could get a disorderly conduct charge there. Now, what's interesting is that she wasn't just videotaping it. She said on the 911 tape, I am videotaping it. So, if when she shows up, she doesn't have that, if it's deleted, she might have just admitted, at least in part, to destroying evidence against her. So, that could also bring her up on other charges. I'm not sure. Hopefully she just provided it to the police and it was used in a case. I don't know. Let's see where it's going now.
And he said, what's the law going to do? They're not going to do anything.
She already did call.
If we don't see it, it never happens. I asked you today, I said, how about murder?
Okay, at that point, yes, I would have absolutely called the police. He's saying, what's the law going to do? Well, you at least have a police report and you start having reports for stalking, harassment, disorderly conduct. You start stacking up those police reports, and then you can get protective orders yourself. They're harder to get in Kentucky than they are in, at least here in Arizona and some other states that I know of. But still, let's have a look at the stalking statute. As used in this section unless the context requires otherwise, course of conduct means a pattern of conduct composed of 2 or more acts evidencing a continuity of purpose. Okay, so that's why I say, even one police report, will they arrest her for stalking? No. But you have a police report showing she conducted 1 act, and then the next time something similar happens, you have a 2nd act. And 1 or more of those acts may include those by which a person directly or indirectly by any means or method follows, monitors, observes, surveils, or threatens another person. Sounds like almost all of those happened in that situation. He should have reported it, gotten a police report, started the paper trail for this charge. The second one, harassment. A person is guilty of harassment when, with intent to intimidate, harass, annoy, or alarm another person, he or she strikes, shoves, kicks, or otherwise subjects him to physical contact. Shouldn't do that because he was inside of his truck. Attempts or threatens to strike, shove, kicked, or otherwise subject the person to physical contact. It does sound like she did do that, and she did it while recording herself doing it. In a public place, makes an offensive, coarse utterance, gesture, or display, or addresses abusive language to any person. Aggressive utterances or displays in other situations. Okay, so it may not have actually gotten a harassment in this case, but it starts a paper trail once again. To me, it does sound like this could have been considered harassing behavior. Then you're also starting a trail for your protective orders here in Kentucky. Your protective orders in Kentucky are harder to get. Petition for interpersonal protective order. A petition for interpersonal protective order may be filed by a victim of stalking. So, like I said, those 2 or more acts, the stalking acts, you start those, then you get the stalking charge, then you can have a petition for an interpersonal protective order. So what is the law going to do? Absolutely nothing if you don't report it. It's very disappointing to hear that he didn't in this case, because I think it could have been the beginning of the paper trail that they needed.
Frances would lay out in her yard topless. She'd be out there mowing her yard naked, showing her butt, mooning them, showing them her boobs.
Montgomery County Dispatch.
Yes, my name is Shauna Scott. Could you send someone to my house, please?
And what's going on?
We're out in our pool, and my neighbor, she was standing in her front door butt naked, and I have kids in my pool.
All right, we'll send somebody up there, okay?
Thank you.
The cops informed us that that's not against the law, so there was nothing we could do about it.
Okay, what we have here in this still frame, she is topless. Now, surprisingly, this was in the I believe this is the still frame that they used for the thumbnail for this video. So I knew this was coming. So we did already look up this statute. Indecent exposure in Kentucky. A person is guilty of indecent exposure in the first degree when he intentionally exposes his genitals, and they are using the he, his in, just the general form. It can be a woman also. Exposes his genitals under circumstances in which he knows or should know that his conduct is likely to cause affront or alarm to a person under the age of 18. So it sounds like in Kentucky, you could, I don't know how they interpret this statute, but the way that it sounds like it here, number one, it sounds like the victim has to be under the age of 18. And number two, you can be fully topless like they were saying there, or like they were showing in that picture. But they did say, well, there's a person out here mowing her yard stark naked. Okay, well, if she's actually stark naked, then that is exposure of their genitals. So I'm not sure why they didn't do anything about that, but that's not the video evidence. Remember, that was an animation that we saw. Maybe they didn't have evidence to show that she was actually, and maybe she wasn't when the police arrived. I'm not sure.
He could come right here at my door right now with a freaking gun and threaten me, and nobody would do a damn thing. Nobody. I have lived like a prisoner here in my own home, but nobody will do anything.
So another thing here in Arizona, we have the Arizona Victims Bill of Rights. They do have to be informed, and they get to put their input in on a plea agreement. The prosecution does not have to listen to the victim, because a lot of times you have victims like that are unreasonable with their requests. 18 months in jail instead of some minimal probation or a fine or an anger management class or maybe all of the above. But sometimes they are just straightforward unreasonable and don't know how the law works or how it should work. And so they just ask for ridiculous things, and the prosecutor has to say, yeah, I can't do any of that. I'm not doing any of that.
I told Shauna right to her face. I said, I am not going to do this anymore. I will not tolerate it anymore. Today is when it stops.
So probably not shocking to people that video is essentially proving premeditation, right? Premeditation can actually be developed in the moment, but if you have several moments, it doesn't have to be I thought about it and planned it out for weeks and months, which, I mean, she might have, I don't know. But it doesn't have to be weeks and months. It can be just 10 seconds of premeditation. The fact that she grabbed a gun, walked across the street, and is on film walking up to Shauna's house, yeah, that definitely is premeditated murder. She was on their property, which was also trespass. I didn't look up Kentucky's criminal trespass statute. A lot of states, if you're trespassing with the intent to commit a felony, it's felony trespass. So it could be that. And then we have her opening the door itself, breaking and entering the dwelling house of another with the intent to commit a felony therein. You've got burglary already. Obviously, she had the intent to kill there, the intent to murder. So, yeah, that looks like it could be a burglary charge. Breaking and entering, it's not literally breaking anything. You're breaking the plane of the home. So just putting the gun in the door, or even just her hand in the door, is breaking and entering. So that one could be burglary. And then obviously very sad, you've got right here,
Bang.
an attempted murder charge, and then clearly a murder charge on Dave. It would be both of them murder in the first degree because very clearly premeditated.
I do not forgive you. I don't want to forgive you, and I'm never going to forgive you.
35-year sentence from a plea agreement. Okay. Yeah, a lot of people going, okay, wait a minute. We're talking about a murder, an attempted murder, and everything else that I mentioned, right? And so, wow, should be looking at life. Yeah, she would probably be looking at life if she went to trial. A double murder, look, I'll be straightforward with you. If it was a double murder and it was a man, it might be looking at the death penalty. But look at the women that are on death row in the few cases or in the few states that actually have women on death row, and they are generally speaking crimes against children. They're not crimes against adults. Whether that's fair or not, that's a different story. But that's generally the way that it goes. In this case, she probably was not looking at a death penalty, and I'm not even sure if Kentucky is a death penalty state. That's actually a good question. Let's look real quick. So Kentucky is a death penalty state, so a theoretical death penalty on the table, but probably not a probable death penalty on the table if she actually went to trial. So practical, what's on the table is life sentence. She pled to 35 years. I don't know how old she is, but it looks like she's maybe in her 50s, late 50s, somewhere in there. A 35-year sentence for all intents and purposes probably is a life sentence. The last factor I would look at is Kentucky, like Arizona, is an 85% state for these violent offenses. So for a 35-year sentence in Kentucky, they would have to serve 29.75 years before being eligible for parole. So essentially a 30-year sentence. Is that fair for actually ending a life and attempting to end another life? Well, tell me what you think in the comments. That's the way that a lot of these do end up going, is that they plea them down because they say, yeah, life is on the table if you go to trial. So instead of going to trial, we'll do this to make sure we get the conviction, and they offer a lower sentence like this. 35 years, yeah, that's in the range of typical. I'll say that.
That's my biggest fear, for Francis to be paroled. My fear for my kids, my family.
Now, hang on a minute. That just said she will be eligible for parole in 2038, which conflicts with the information that I just got. I'm not sure. You know what? Let me go back to that one more time because I want to know who's right. Okay, so Kentucky is an 85% state, but, okay, and I am looking at, this is 501 KAR 1.0.3.0. Determining parole eligibility, and down here in section E4, committed on or after June 26, 2007, which is a Class A felony, and murder is in fact a Class A felony. Sentences and number of years, 85% of a sentence received, or 20 years, whichever is less. Sentences of life, 20 years. Okay, so part of this does say 12 years, which is how they would get, looks like 2038. But then this says 85% of the sentence or 20 years, whichever is less. That looks like it would be 20 years. So I'm not sure how they got the 12-year statute to apply. That 12-year statute looks like, let's see, which is a capital offense Class A felony, Class B felony, where the elements of the offense or judgment of the court demonstrate the offense involved death or serious physical injury to the victim. Okay, that definitely applies. Okay, or committed on or after June 26, 2007, which this crime was. Let's see. And Class A felony, Class B felony involving death. It sure looks like Section E4 should apply, which is 85% of the sentence received or 20 years, whichever is less, which would not make her eligible for parole until 2046. So I'm not sure where Netflix is getting the 12 years from or how they're applying the 12 years. It's a possibility. They may have just heard it at the sentencing, and they may have been applying the statute in a different way than I'm familiar with. Like, I don't practice in Kentucky, but it looks to me like it should be the 20 years, which would make her eligible for parole in 2046. If anybody knows how they got the 12 years to apply, please let me know in the comments. I'd be interested. Pretty heavy episode there. A whole lot happened there, and a whole lot that could have been done differently. I mean, watch out for yourselves. If somebody is committing a crime against you, even if you consider it a minor crime, call the police and report them. Yes, that looks like exactly what Francis was doing all the time. You're reporting every single thing, and we don't want to be Francis. I totally get that. But at the same time, could have gotten protective orders, could have gotten a harassment charge, could have gotten a stalking charge, might have actually gotten her away for some time before this ever happened. Yes, it's 2020, and I wish the family all the best, and thoughts and prayers for them. Hope they find peace. But all we can do is just look at what could have been done and try to do better. So let me know, do you want to see more? I know that this is a mini series. There's more episodes. So if you want to see more of these, let me know in the comments. Otherwise, see you next time.